up so that it's running, and let's see if I can make it work. What I'm trying out is that I'm doing you guys on both the YT and the TT at the same time. But the way that I have to do that in order to see, see people on the other one is to open it in, like, on the internet. So give me 1 second. I'm going to get this running so that I can see them. I got it to work yesterday, or a couple days ago, whenever it was. Let's see here. How about, I think that'll work. Make sure the volume is not up. Sorry. Oh, hopefully this works. Okay, we'll find out in a minute. So, hi everybody. All right. Kind of excited about this conversation that we're about to have. Good evening, Bendy. How are ya? So, we're going into some very uncharted territory here, because what happened is that earlier today, I was sitting down and looking at, I was prepping this for tomorrow, and unfortunately, I think I'm going to have to push it back to, hello, Blue Horizon, happy Sunday. I think I'm going to have to push it back because I've realized just how much research I have to do before I can properly answer this question. The question is about some people are worried about saying his name on here, and I hope it doesn't get me into trouble, but Luigi Mangione. There's something about his case that has really bothered me from the beginning, and I'm going to try to find an answer to it. I actually bought a book just to find the answer to this. I bought a very expensive book, you guys. This is a federal courts case book. It was incredibly expensive, and I bought it just to find the answer to that question. And it's not in there. And I was really, really annoyed. And the question that I'm trying to figure out is how it is that Luigi Mangione is being tried in both a federal and state court. And I know some of the underlying theories, but it still doesn't quite make sense. It doesn't quite sit right, and I couldn't get my head around it. I couldn't figure it out. So the other night we did something where we went through the First Amendment, and every 15 minutes I read you guys the First Amendment. Tonight I have a limited time tonight. I can only be here for an hour. So every 15 minutes I am going to read you guys the Fifth Amendment, because tonight we are talking about the Fifth Amendment. So I'm going to start that right now with a reading of the Fifth Amendment of the U.S. Constitution. Are you ready? Here we go. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So there's a lot in there. The thing that I'm focusing on this evening is the double jeopardy clause. Hey, how's it going, Dennett? So the double jeopardy clause says, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. So, how exactly is it that Luigi Mangione is going to have to go through 2 trials for the same crime? And this has been bothering me for a really long time. So the one thing I did know and that I kind of understood is that the federal and state legal system, thank you, can have, hey Jennifer, can have concurrent jurisdiction over something. And so there can be both a federal and state law about something, and often they pick one. They do one or the other. I didn't really see it a ton where they did both, and I kind of didn't know they were allowed to do both, to be honest. And I was sort of thinking that when they charged him with both, one was going to sort of win out. And then it appears, no, not at all. And I love the little dinosaur. It's so cute. So I had read, and what I was going to present for you guys tomorrow was this decision that they gave us last week, where they went through. They have removed two of the charges. They have dismissed two of the charges against him. And most of the decision that they put in here was about that. And really, I could just present it tomorrow based on that. But this one problem is not gonna let me off. Did they talk about this in Derek Chauvin as well? It might be. And so, it's one of those things. It's really annoying because I'm a lawyer. I should know the answer to this question. This is something that feels very fundamental. I was a prosecutor. I should really know the answer to this. So why don't I? Well, I don't know. Somehow passed me by, or I knew it at one point and just forgot. I don't know. But we are going to look tonight at a case called Gamble v. United States. Gamble v. United States is a 2019 case where the Supreme Court considered something called, and let me find it here so I can read it correctly, the dual sovereignty doctrine. Dual sovereignty doctrine. So, the idea of sovereignty. The idea, if we were in England, the king would be sovereign. The king is the one at the top. The king is the most important person. And at the end of the chain of command, you always have the king, the sovereign. Well, in the United States, things are a little funny because we have kind of a funny relationship with sovereignty here, because at the end of the day, people are sovereign, right? The people of America are the sovereigns. But then there's also this federal government that's sort of in charge sometimes. There's also the state governments that are sort of in charge sometimes. In the grand scheme of things, the people are in charge. But of some things, the federal government is sovereign. Of some things, the state government is sovereign. And this case is about the idea that in some cases, there are two people in charge. And it's based on this other theory. Sorry, I'm going to have to jump over into a whole other philosophy for a second. Sorry, let me be sure. Do they consider it double jeopardy if it's two different court levels? So, well, that's what we're getting at. The difference between a civil case and a criminal case, well, there's lots of differences, but one of the big ones is that a civil case is something where this is Gamble v. United States that we're going to be talking about, but we're also talking about the Luigi Mangione case. A civil case is something where one person has hurt another person in some way, has damaged another person in some way. A criminal case is where one person has damaged society. In a crime, you may think of a crime as something that a person does to another person, but sometimes it's not. There are crimes that don't have an actual victim. But the victim in every criminal case is society at large. Society is hurt when a crime is committed. And there's a whole big philosophy I can go on for quite some time about this. Hey, Timeless Light, how's it going? There's this whole big theory behind it, but this is where we get the idea of paying your debt to society, because you have harmed society and you owe society something. So here's just a silly little example that I think may help illustrate this, or it might just make it super confusing. I don't know. But if it would normally take me, if I want this duck, and this is a $1 duck, and I make $1 an hour, it would normally take me 1 hour to earn this duck. If instead I break a window and steal this duck, then I have sort of stolen an hour of work from the world. I've taken a bit of a shortcut to get this duck that I want. And so I owe the world that hour back, that dollar back, that whatever back. And so that's kind of the idea of repaying your debt to society. When you commit a crime to something, you are sort of taking a shortcut in some way towards getting whatever it is that you want. and we are making you kind of repay that shortcut that you took. This is one of several theories, so I don't want to get lost in this, but okay. General idea is that with a crime, you are hurting society. And so you are under this sovereign. You are causing damage to your society. And if that society is your state, then that state is going to charge you for that time back, for whatever back. If you are doing it to the federal government, then they're going to come after you for it, for your time back or whatever. This is like a grand theory, so don't try to get too stuck in the nuts and bolts here, but I could really turn this into a 3-hour lecture. I'm trying to skip past some of these points. So the idea here is that with a dual sovereign, in some cases, you have committed a crime against both of these entities. You have hurt both your state and the federal government, and so both of them are allowed to come after you for whatever it is that you took. And so that is the idea. I would love to teach law school. That would be great. That is apparently the idea that they're going to go into here. But I want to read just the beginning of this, and we're going to come back to some other stuff, but just the very opening paragraph of this says, "We consider in this case whether to overrule a long-standing interpretation of the Double Jeopardy Clause of the Fifth Amendment. That clause provides that no person may be twice put in jeopardy for the same offense. Our double jeopardy law is quite complex, but at its core, the clause means that those acquitted or convicted of a particular offense cannot be tried a second time for the same offense. But what does the clause mean by an offense? We have long held that a crime under one sovereign's law, state, is not the same offense as a crime under the laws of another sovereign, the federal government. Under this dual sovereignty doctrine, a state may prosecute a defendant under state law even if the federal government has prosecuted him for the same conduct under a federal statute. Or the reverse may happen, as happened in this particular case of Terrence Gamble, who was convicted by Alabama for possessing a as a felon. So that is the case that we're getting into, because how do you make that work with the Fifth Amendment? And I don't know yet. I just printed this out and I was like, I'm going to go live with this. We're just going to talk our way through it. But I at least wanted to get through some of the underlying concepts, because before I present this and present the Luigi Mangione case and explain why it is that the court said, because they do say in here, he brings up a double jeopardy argument and the court rejects it. And I was like, why? How? I don't understand. And so this is how we're going to get our answer. And it might honestly take me, it's going to take more than this live, frankly, to get a good answer to this, I think. But we're at least going to get it started, and we're going to find out, get some of the answers out of this, because it's like an 85-page thing. But we're going to get started, and I thought I'd drag you along with me here. And I'll tell you what we're going to do. We're going to start actually at the end, because of all people, the two dissenting opinions, and this is where I said, oh, this is going to be fun. The two dissenting opinions in this case are Justices Ginsburg and Gorsuch. So Justices Ginsburg and Gorsuch are the two justices that dissented in this case. So this is going to be fun, right? I mean, this is going to be an argument. And so I thought the best place to start might be with Gorsuch's dissent, because it's a little bit shorter, and it might be, I don't know. I just feel like it's going to be an interesting place to start. And I cheated and I looked at the first couple of lines of it and I was like, this is exactly where I would have started, I think. So let's hear what he has to say. So for those of you who have just come in, the holding the holding is that they do support it. They keep it in place. And to this day, we still allow this dual sovereignty. This is only a 2019 case, so it's just a few years ago, but this is an old doctrine. But they were going to decide in 2019, are we going to overrule this? And apparently they decided not to. And I can tell you here, just because I was really a little bit surprised by the people who kind of came together for this. And let me see if I can find it in here. See, I know it'll say it right here somewhere. Here we go. So, are you ready for this group? Because this is hilarious. Justice Alito delivered the opinion of the court with Roberts, Thomas, Breyer, Sotomayor, Kagan, and Kavanaugh. And then Justice Thomas filed a concurring opinion. Like, he agreed with them, but he also had some stuff to say. And Ginsburg and Gorsuch filed dissenting opinions. Woo! Okay. So, once again, for those of you who were I started looking at the this new Luigi Mangione opinion from the other day, and one of the things that they did was rejected his argument that there was a double jeopardy problem here because he's going to be tried in both federal and state courts for the same crimes, and I thought, yeah, wait, what? So that has just really bothered me. So I found the court. Oh yay, thank you. So I found the case and I looked it up. Thank you. And so you're gonna heart me over. So we're gonna go actually. Yeah, I'm gonna do it in 1 second because we're about a minute out. I'm gonna go ahead because I said every 15 minutes tonight I'm going to be rereading the Fifth Amendment. Because tonight, that's really what we're focused on, is the Fifth Amendment. And there's a lot of stuff in the Fifth Amendment. It's a lot. It's where the original idea of American due process came from. It's got grand juries in it. It's got, what do we call it? A martial law, essentially, in it. It's had all kinds of stuff in it. But it also has double jeopardy. So this is a big thing. So let's go ahead. I'm going to read this. And here we go. So, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising on land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Okay, so there we go. That's our Fifth Amendment. And the part in the middle is what we're talking about, the being subject to the same offense, twice put in jeopardy of life and limb. And I will tell you about the guys, by the way, because I think this is an interesting point. Jeopardy, which means what it sounds like, attaches, as they say, when the jury is impaneled. So up until the point where they bring in a jury, you are not in jeopardy. That is what the rule is. As soon as the jury is sat down, that's the moment that you are considered to be in jeopardy, and from that moment forward, they can't try you a second time. Except, apparently, in this case. So, let's take a look at what Justice Gorsuch had to say in 2019 about this. A free society does not allow its government to try the same individual for the same crime until it's happy with the result. Unfortunately, the court today endorses a colossal exception to this ancient rule against double jeopardy. My colleagues say that the federal government and state are separate sovereigns, entitled to try the same person for the same crime. So if all the might of one sovereign cannot succeed against the presumptively free individual, another may insist on the chance to try again. And if both manage to succeed, so much the better. They can add one punishment on top of the other, but this separate sovereign's exception to the bar against double jeopardy finds no meaningful support in the text of the Constitution, its original public meaning, structure, or history. Instead, the Constitution promises all Americans that they will never suffer double jeopardy. I would enforce that guarantee. That is some harsh words right there for everybody else in this case. I participated in my first grand jury indictment. It was very cool to observe the procedure. It is a really cool idea, and particularly, the joke is always that the grand jury doesn't do much. A grand jury will indict a ham sandwich is the running joke. But we are seeing right now the grand juries in Washington, D.C. are refusing to indict people because they are unhappy with the way the law is being enforced. So that is a pretty interesting use of. That's exactly how the Fifth Amendment was imagined. Is that the people, the American people have a voice in the actual, like, and not through their elected representatives, but individually they are brought in to have an actual voice in the implementation of the criminal laws in their local jurisdiction, that's pretty democratic. That's pretty cool. I've only had jury duty that I was able to attend, I think, once. And I went in and I wasn't called. And then, I've had it other times where I was out of town or something. But, yeah. But I've also been told that if you are actually called as a lawyer, they will always send you home. They don't want you. But yeah, the grand jury is really cool. So they are both considered. They call it a grand jury and a petit jury, which just means big and little. But the grand jury is impaneled for longer. I think 28 days. Depends on the state. Everybody's got their own rules. So okay, so let's take a look here. Fear and abhorrence of government power to try people twice for the same conduct is one of the oldest ideas found in Western civilization. Throughout history, people have worried about the vast disparity of power between governments and individuals, the capacity of the state to bring charges repeatedly until it wins the result it wants, and what little would be left of human liberty if that power remained unchecked. To address the problem, the law in ancient Athens held that a man could not be tried twice for the same offense. The Roman Republic and Empire incorporated a form of double jeopardy protection in their laws. The Old Testament and later church teachings endorsed the bar against double jeopardy too. And from the earliest days of common law, courts recognized that to punish a man twice over for one offense would be deeply unjust. I want to remind you guys, I think a lot of people out there think of Justice Gorsuch as having a particular set of ideals. So this might be, I just want to remind you, this is Justice Gorsuch talking here. The rule against double jeopardy was firmly entrenched in both the American colonies and England at the time of our Revolution, and the Fifth Amendment, which prohibited placing a defendant twice in jeopardy for the same offense, sought to carry the traditional common law rule into our Constitution. As Joseph Story, who's a very famous judge, put it, the Constitution's prohibition against double jeopardy grew from a great privilege secured by the common law and meant that a party shall not be tried a second time for the same offense after he has once been convicted or acquitted of the offense charged by the verdict of a jury and judgment has passed thereon for or against him. So this is, if we think of the jury as being this check on the power of the government here, the people's check on the power of the government, to try the person twice is very much contrary to that power. Obviously, someone tried and a local government tried. So I think what you're saying is, so I don't know if this works as well for state and local. I don't know. I am still learning. I'm learning here, so I'm a little bit surprised to see this at all. I really did always think, and I remember when Mangione was first charged with both crimes, people kind of asked me about it, and I was like, I I'm not positive about this, but I think that they have to just pick one. I don't think he can be charged. The Fifth Amendment doesn't allow him to be charged twice. So I'm pretty surprised to see this myself. This is 2019. Yeah, it does seem odd. But again, this is apparently rooted in we've skipped over the main opinion and gone to this Gorsuch opinion because I thought it was a little bit faster place to start. I had a feeling that if we started the main opinion, we were going to be there all night. But I have a feeling that what this is rooted in is a lot of really old case law that for some reason had recognized the power of the two. And my guess is that there was probably a lot less crossover. Hey, JTA, I'm guessing there was at one point a lot less crossover than there is today, but I don't know. Fox and something said that they're separate, state and fed. That might be what this is rooted in. I don't know. I guess we'll find out. So, given all this, Mr. Gamble, who is the defendant in this case, or the appellant, should have won his case handily. Alabama prosecuted him for violating a state law and sentenced him to a year in prison. But then the federal government, apparently displeased with the sentence, charged him with being a felon in possession of a firearm. Gotta watch those words, Brian. Based on the same facts, ultimately a federal court sentenced him to 46 months and 3 years of supervised release. Most any ordinary speaker of English would say that Mr. Gamble was tried twice for the same offense, precisely what the Fifth Amendment prohibits. Tellingly, no one before us doubts that if either the federal government or Alabama had prosecuted him twice on those facts, it surely would have violated the Constitution. So we know that neither of the individuals can do it. This is the appellate case. Yes, yeah. Explain the two guilty of Diddy. I don't know enough about the Diddy case to talk. So, how does the government manage to avoid the Fifth Amendment's seemingly plain command? On the government's account, the fact that the federal and state authorities split up the prosecutions make all the difference. Though the Double Jeopardy Clause doesn't say anything about allowing separate sovereigns to do sequentially what neither may do separately, the government assures us that the Fifth Amendment's phrase, same offense, does this work. Adopting the government's argument, the court supplies, we're going to go through a logical syllogism, which an offense is defined by a law, and each law is defined by a sovereign. So if there are two sovereigns, there are two laws and two offenses. So this is the idea that, if he's being charged with possession and conspiracy or something, that those are two different crimes. But here they're saying if he's being charged with federal possession and state possession, those are also two different crimes. So that's the question here. All right. Well, it's not really an answer to that, but okay. All right. But the major premise of this argument... Okay, so anyway, let's talk about this for a second, because if this whole system is supposed to be set... I love that. It's funny, because I don't look good in hats in real life, but I actually look pretty good in the TikTok hat. If the entire premise, if the entire purpose of this is to avoid having someone, to only allow someone to be charged with a crime once, and if they are acquitted, and we know, we have this idea of jury nullification, where even if members of the jury believe that the person has committed the crime, they can still find them not guilty if they want. They are allowed to do that. They have the power to do that, and the court cannot overturn that decision. Now, they're also not allowed to ask. Hey. But that's called jury nullification. And that is built into the Fifth Amendment as well. That is the power of the jury. That is the power of the people in America as its own sovereign, stepping in and overpowering the government, the legislature, the imposers of the law, if they so desire. And so to be able to essentially send this through two different sets of juries if you don't like the outcome really does run, it would seem, contrary to that idea. So we have to understand where this is coming from and how this is rooted. Because I'm going to say that with this coalition of Supreme Court justices agreeing to this, thank you. Thank you, Dominican. Agreeing to this, there is almost got to be a pretty solid counter argument. Just a reminder, that is, from very opposite sides here. We have, what was it? Kagan, Sotomayor, Alito, Breyer, Roberts, and Thomas all agreeing on the opposite outcome here. So there's got to be some good logic here. And so Gorsuch is going to go on here. Now he's going to start going into, he's going to go way into Athenian law, and he's going to go, there's more interesting stuff here. But I'm going to take a break here and pop over and take a look at some of these other decisions for a minute. Oh, I see what you mean about it being related to the Pew Pew situation, and we may find out that that's the reason, but I'm not seeing that as the reason yet. So, according to this, the idea that it could be federal anything, as long as there is a federal law and a state law, you can violate both of them, and there are two different laws, and they can charge you with both of them. That is what it's saying here. You cannot arrest someone by way of information only when it is to be indictment by a grand jury. Yeah, that's correct. So information, I think, is a state term, so it kind of depends on what state you're in. But it's just gonna be a state. Oh, I missed a heart. Ah, shoot, sorry, Joe Mack. Thank you, I missed it. And grand juries are not required for, well, I'll tell you what, guys. We just hit our good timing, because we just hit our 15 minutes again. And so, for those of you who haven't been around, every 15 minutes tonight, although this is halfway through, so I'm only staying for an hour, I'm going to be reading the Fifth Amendment, because that's what we're looking at tonight. So let's read the Fifth Amendment one more time, and then we will listen for what this says about grand juries. When are grand juries required? We'll talk about that in a second. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. So yes, there was a grand jury for him, and actually, notably, they said, because one of the arguments that they talked about here was there are several, they were trying to attach federal or state terrorism charges, and there are apparently 3 different prongs of the state charge there, and there's 3 different ways you can justify it, and the federal government is now saying that number one is their go-to. It's really their argument. Number 2 is a little bit their argument. Number 3 they've dropped. Number 3 they don't think at all. And the court said that because number 2 was rejected by the grand jury, they're not accepting it either. So they end up only discussing number 1. So let's see here. Hold on, let's see here. I missed a couple of things here that I think were important. So we're going to come back. Don't let me forget Independent sovereign doctrine is erroneous because states are subject to the U.S. Constitution. So I'm not sure I disagree. We're just trying to figure it out because I didn't know anything about it until today. State level crimes. My state does not require even for capital cases. Well, what state is that, Blue Dot? Because I think they're required to, but maybe So one of the things about, and I'd have to look, the Fifth Amendment was only written to apply to the federal government. So it has been individually applied to states, but I can't remember. I thought that particular one was applied to state, but maybe not. Public danger. I don't know. Can you tell me what? Oh, public danger. Are we talking about? I'm not sure. You got to tell me what context we're talking about public danger in. Okay. So, but here's the thing: no person is held to, except for a grand jury, for a capital or otherwise infamous crime. And I did a video about this the other day because Nebraska, interesting. I don't know. I would have to. I just don't know off the top of my head, and I would have to look up why. But so infamous crime. There was a thing that just happened here where I'll look at public danger. Give me a sec. When the guy was being charged for throwing the sandwich. The kind of cutoff apparently is if the maximum penalty is over a year in jail. I think that's it. Just off the top of my head. So, but I think it's if the maximum is over a year in jail, then it's considered an infamous crime. So if it's either a capital crime, over a year in jail, or over a certain amount of money, then it's considered an infamous crime and it requires a grand jury. Anything less than that is considered a misdemeanor. And so what they ended up having to do, because they couldn't get a grand jury to indict him for anything, quite literally couldn't get a ham sandwich indicted, they gave up and they moved to because they weren't going to give up completely because it was way too high, too many people were watching. So they dropped it down to something that was below that misdemeanor line so they didn't have to get a grand jury involved. How do I keep all of this knowledge in my brain? It does hurt. It hurts all the time. As a matter of fact, on a day that I overdo it, I will quite literally give myself a headache. If I read too much, if I think too much, I will hit a point in the day where I can feel like pressure building in my head, and I'm like, stop, or you're going to be in trouble. And if I don't, and sometimes I don't, because I'm like really stubborn, I'm like, I will find the answer to this question, I will end up miserable in bed with a headache, and sometimes it lasts until the next day. So, yeah. What was the public danger? Where did it say public danger? Hold on. D-A-N-G. There we go. When an actual time of service or public danger. I don't know. So this is that's cute too, Christopher. So this is the public danger thing. It's related to when they're allowed to use the military tribunals, and that is a whole area of law, and it's one that I've read recently, and I just can't pull it up right now. I'm sorry. It's too far back in my brain for me to pull it out. But there is like a body of law around it. The one thing I'm thinking of is I know that there was a whole thing around because they started using military tribunals in Honolulu because the federal courts were closed right after Pearl Harbor. And so this guy was charged in a military tribunal for like kind of a regular offense. It was like a pretty normal offense, but it was just, it was the only court available. And so they sent him to a military tribunal, and I think his charges were later overturned because they should have found a way to get him. It wasn't high enough, even then. So, infamous. Yeah, infamous. It is. I think there's a line. The line has to do with, I think, the maximum prison sentence is 1 year. I think that's it. but I also could be a little bit off, but it's something pretty close to that. And I do think it may be, you know, the difference between jail and prison, which I can never remember. Okay, so, here's what we're going to do next. All right, now let's take a quick look. I'm going to jump over to Justice Ginsburg's dissent, and let's see how she starts out. We're just doing the beginnings here because, you know, they're going to go off on their little things. Let's see what she has to say, though, and see if it's just the same argument again. I don't know. Usually, if it's exactly the same argument, they'll just agree. You know, they won't write two different ones. Oh, I missed a lightning bolt, too. But, hey, Michelle, how you doing? So, let's take a look here. Okay, so, all right. God bless Justice Ginsburg. I hate Ginsburg opinions. I know, so many people. Do you know anything about the 1948 Smith-Mundt Act? Not off the top of my head, no. In Florida, any sentence greater than 365 days, goes to state prison. So I think that's exactly the split between a misdemeanor and a felony. So let's see here. So she's gonna go straight into Terrence Martez Gamble pleaded guilty in Alabama state court to both possession. And also there was possession of both a thing and a chemical possession. And was sentenced to 10 years imprisonment, all but 1 year suspended. Apparently regarding of Alabama's sentence as I see. Because they thought Alabama's sentence was too lenient, federal prosecutors pursued a parallel charge in violation of Gamble again pleaded guilty and received 3 more years. Oh, so these were pleas as well. Ooh, interesting. Had either the federal government or Alabama brought the successive prosecutions, the second would have violated his right not to be twice put in jeopardy for the same offense. Yet the federal government was able to multiply his time in prison because the doctrine that for double jeopardy purposes, identical criminal laws are the same offense. So this is interesting because she's sort of suggesting here, and again, I'm going to have to dig through this a little bit more to find out for sure, but let's see here. Whether this has to do with the fact that it was a plea, but that wouldn't work with the Mangione case, so I'm not really sure. And your option is, okay, I don't know what that meant. Do you know anything about, okay. I don't know what the heck he's talking about. Okay. So, let's see. So, she dissents from the court's adherence to that misguided doctrine. Instead of frittering away his liberty upon metaphysical... Yeah, this is the problem. Ginsburg had some... I can never follow a Ginsburg opinion. All right. I would hold that the double jeopardy clause bars successful prosecutions for the same offense by parts of the whole USA. Let's see. Gamble urges that the double jeopardy clause incorporate English common law. That law, he maintains, recognize a foreign acquittal or conviction as a bar to retrial in England for the same offense. So in England, it would have been, even if you'd been convicted in another country, they couldn't do it again. So that's interesting. And remember that this is the root. We are using that, we're importing these directly. So let's see here. Can California stop federal officers from wearing masks? We're going to find out. I'm sure it's going to be a big case. So I don't know. You know what? There is no point in even guessing the answer to that question because it's definitely going to go. It's going to be probably. Well, tell you what. Here's the thing. I want to say that whoever came up with the law probably knows that it's going to get argued about. So, they probably have a pretty good argument ready, but I'm guessing that the supremacy clause is going to take over. Oh, I'm missing something back here. Sorry, guys. I was trying to pay attention to both windows. Yes, Gustav. Some states are weird. Yes, there's a lot of questions here about who counts as in a militia. Militia is the National Guard. When the Constitution talks about militia, they're talking about the National Guard. When the federal government talks about militia, they're talking about the National Guard. Okay, I think the court will allow the mask if they argue. So there, I mean, but it's going to be a question of if it conflicts with federal law. There might be a supremacy clause question, but I don't know. We're going to have to see. And again, until we start seeing the arguments hashed out, I can't even guess. I gotta find a better way. I've been trying to figure out a way to be able to look. What I have here, guys, is two phones going at the same time because it was the best way I come up with to talk to both YouTube and TikTok at the same time. But the problem is I have not found a great way. YouTube does not make it easy to see the people talking. And I have not figured out a great way to do this, but I'm working on it. I'll figure this out. Okay, have I read all the books on the bookshelf? Well, like this whole set, this Durant set is kind of a reference manual. I've read chunks of them, but not all of them. Some of these are old grammars from when I was an undergrad. So you know, like I used to buy a lot of because I was studying Greek and Latin. Hey, Willow. So I have a lot of Greek and Latin books that you don't read from start to finish. But have I opened them all? Yeah. I mean, have I read parts of them? Yeah. So I don't know about that. That's a good question. All right, so I'm kind of skipping. I was hoping to get a little bit more out of this Ginsburg opinion than I did, but I think I'm gonna have to like really focus on it. I really have trouble reading her, and I know how people feel about her, and I don't mean to, but I just have a tough time reading what she says. It's just not written in the same way that my brain thinks. So that's it is what it is. Oh. Thanks, Uncivil. I'm sorry. I just haven't. Oh, there you are, and I see now. I see it. Okay. Oh, and here we go. We're at 15 seconds. So the thing that I'm doing tonight is every 15 minutes, and this is my last 15 minutes, unfortunately, because I do have to go to dinner. Have to do dinner after this. I am going to be reading the Fifth Amendment. So, because that's what we're talking about. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising on land or naval forces or in the militia, which is the National Guard for whoever just asked that, when in actual service of time in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Okay. So, there we go. There's our Fifth Amendment again, which is what we're looking at. And a grand jury, I did say, yeah, the grand jury, I read this and I was so excited about it. The idea that grand juries and or juries in general and militia have this weird parallel idea because they are both meant to be methods of the people to hold back the federal government, and I think that is fascinating. That each state is supposed to have its own private military, so that there is kind of collectively a force that can fight back the federal government. That's what the militias, the National Guards, are partially for. And in the same way, the juries are a way for individual people to have their own say in how the laws of their state and government and federal government are imposed in real time. So it's just such an interesting concept that, thank you for bringing that up, Tyler, that juries and militias both have this kind of parallel ideology behind them. I was like, that made my head go. All right, so I'm gonna I'm sorry, I'm going to skip away from Justice Ginsburg for a minute because I just can't. All right, we're going to look at Alito here. We consider in this case whether to overrule the long-standing interpretation of double jeopardy that provide. We have long held that a crime under one sovereign's laws is not the same offense as a crime under the laws of another sovereign. And again, we're talking about this because we were looking at this Luigi Mangione case where he's being tried in both federal and state court. Is the National Guard a well-regulated militia? Yes. Yes, it is. It is it is the well-regulated militia. Which is why judges hate jury nullification, indeed. Okay. So, let's see. So we're going to go through the facts, which I'm going to sort of skip over here. Gamble contends that the Double Jeopardy Clause must forbid successive prosecutions by different sovereigns because that is what founding-era common law did. And before turning to that historical claim, see Part 3. All right. We review the clause's text, and some of the cases Gamble has asked us to overturn. Perfect, because I was hoping to see some history here. And, again, I knew that eventually I've got about 11 minutes left because I'm going to get in trouble if I don't make it downstairs for dinner. But so we're going to start with the text of the First Amendment. Oh, thank you, Alito. Again, the writers, whether you like these people or not, the writing styles, Alito always writes in a particular order, and it's a little bit clearer sometimes. So we start with the text of the Fifth Amendment. Although the dual sovereignty rule is often dubbed an exception to double jeopardy, it is not an exception at all. On the contrary, it follows from the text that defines that right in the first place. The language of the clause protects individuals from being twice put in jeopardy for the same offense, not for the same conduct or actions. Ooh. Interesting. Okay. Anytime you want to geek it out on common law? Okay. All right. Uncivil law. Uncivil law did a very nice piece on me at one point. I would never forget that. That was awesome. Thank you. So this is where they are starting, guys. This is interesting. An interesting point is that what they're saying is it's not about the offense, or it's not about the conduct. It's not about the fact that he did something wrong and you can't charge him twice for doing that same wrong thing. It's about whether or not you can charge him for violating law number 1, law number 2, offense number 1, offense number 2, offense number 3. And so they're saying it says it right there in the text. As Justice Scalia wrote in a soon vindicated dissent, the term offense was commonly understood in 1791 to mean transgression. That is, violation or breaking of a law. So offense is an act committed against a law or omitted where the law requires it. As originally understood then, an offense is defined by law, and each law is defined by a sovereign. So we're talking about these different sovereigns being the state and the federal governments. Each one of them has their own statute here that they are charging Luigi with violating, and so that is why they're saying that they are allowed to do it twice. And again, the question, whether or not that's actually what this means or not, we can talk about, but this is what they're saying here. Why did the dissent have to be so long? I don't know. They're always so long. But, I'll tell you, if you listen to me talk, I can't ever answer a question in a short period of time because I'm just constantly thinking about all of the little side notes, this is mostly true, but then there are 3 situations where it isn't true, and I feel like I have to tell you about those, or else I'm not giving you the full answer. And I wouldn't feel right if I said, yes, this is the answer, and I didn't tell you those little subnotes, because that's just how our brains are, the lawyer brain is taught to work. And so that's what they're doing. They're going through all of them, and it's really annoying. And Lion's Roar says you don't agree. I'm not sure I do either, but I'm at least telling you, what they're saying here, so we can sort of understand why they said it. Because I couldn't even get my head around it. I was looking at Gorsuch's opinion and I'm like, yeah, that makes sense. I cannot think of another way to think of this. And this is another way to at least logically think of it. So, faced with this reading, Gamble falls back on an episode from Double Jeopardy Clause's drafting history. Okay. The first Congress, working on an earlier draft that would have banned more than one trial or one punishment for the same offense, voted down a proposal to add by any law of the United States. In rejecting this addition, Gamble, the defendant, says, Congress must have intended to bar successive prosecutions regardless of which sovereign brought the charge, whether it's the state or the federal government. Even if that inference were justified, something the government disputes, it would count for little. The private intent behind a drafter's rejection of one version of a text is shoddy evidence of the public meaning of an altogether different text. So he's just sort of saying, which I was hoping for a little bit more there, to be honest. But I also just realized, for some reason in my head, did I read that right? Yeah. For some reason in my head, this was Scalia already, not Alito. And I was like, this isn't quite as good as I thought it would be. It's because it's Alito, not Scalia. But besides, if we allowed conjectures about purpose to inform our reading of the text, the government's conjecture would prevail. So they're saying that if we were letting that happen, they would probably end up anyway. The government notes that the Declaration of Independence denounced King George III for protecting British troops by a mock trial from punishment for any murders which they would commit in the states. So this is a whole thing about the Boston Massacre. It's an interesting side story, but I'm not sure it's relevant. A law that allowed British officials indicted for murder in America to be tried in England beyond the control of local juries. Now, this is interesting and something I have been talking about this week, because the idea of making sure that everyone is tried with a local jury has been around for a really long time and is very, very important to America. Like, we consider that super important, that a local jury be the one who tries people. And that was one of the big things that Britain did that really ticked people off, is that they said that they were going to move people to, hey, Betharoni, how's it going? That they were going to move people to back to England. They were going to move British soldiers back to England to be tried, where they could get a better jury. During the late colonial period, Americans strongly objected to this circumvention of the judgment of victimized community. Okay, they didn't like that. Yet on the defendant's reading, the same founders who revolted against acquittals abroad would give us an amendment allowing foreign acquittals to spare domestic criminals. Okay, so what they're saying here is, that we mentioned, if you heard this a minute ago, that apparently in England, if you were acquitted in another country, you couldn't be tried again in England, because that was the only way to come up with a kind of parallel here, right? There weren't two sovereigns there. There was only one sovereign. There was the king. Here we have two sovereigns. So there they were talking about, when they said two sovereigns, they meant, England and the Netherlands, not England and, West Ham. So this is, I don't know, it's England and London. I don't know. They're trying to make these two parallel. I don't know. It feels a little stretchy. Our cases reflect the same reading. A close look at them. Okay, so this is what I want to see, is looking at the old case law. So the question of successive federal and state prosecutions arose in 3 cases before the Civil War, spelling out how dual sovereignty doctrine. Okay, so someone asked me about Fox, and here we are. Whoever brought up Fox, Oh, somebody, I missed a hand heart. Sorry, thank you. Whoever brought up Fox, good job. Was that you, VSP? Somebody brought up Fox. Fox v. Ohio, 1847, involved an Ohio prosecution for counterfeit coins. The defendant argued that since Congress can punish counterfeiting, the states must be barred from doing so, or else a person could face 2 trials for the same offense, contrary to the First Amendment. We rejected that premise under the Double Jeopardy Clause. Offenses falling within the competency of different authorities to restrain or punish them would not properly be subjected to the consequences which those authorities may ordain and affix their perpetration. So this is 1847, so a little flowery. Indeed, we observed the nature of the crime or its effects on public safety might well demand separate prosecutions. Generalizing from this point, we declared in a second case that the same act might, and the consequences it involved, constitute an offense against both the state and federal governments, and might draw to its commission the penalties denounced by either. Okay, and this is U.S. v. Madrigal, which is 1850. So the point here is that sometimes they're saying it has to make sense that sometimes you've wronged the state and sometimes you've wronged the Fed, and they should both be able to bring a case. But the question of whether or not they should always be able to bring a case when you have not necessarily wronged them both, I think is a different question, and I would like to see that kind of looked into a little bit deeper, because I can see where the two may have slightly different interests and therefore slightly different statutes. Thank you. You know what I mean? Like, they might have a slightly different law that does slightly different things, and so prosecuting both of them sometimes could make sense. But that doesn't mean that it always does. And again, I'm still looking here, so I'm just kind of thinking out loud here, and I'm bouncing this off of you guys. But unfortunately, I said I was going to do 4 15-minute sessions, and we're hitting it. Luigi didn't do both. So Luigi is being tried in both, and so that's part of what we're looking at. I am going to continue doing this in a later thing, but we are going to go through one more time, because I think this is important. The Fifth Amendment. All right, everybody here? No person shall be held to answer for a capital or otherwise infamous crime, which is not a misdemeanor, it's anything big, unless on presentment or indictment of a grand jury. So you have to have a grand jury if you're going to be in jail for at least more than a year, whatever. Except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Okay, so, yeah, I gotta wrap up because I gotta go have dinner. Thank you, Timeless Light. But thank you all very much for coming in. And like I said, I probably will, because I've got more to read here before I really want to answer this Luigi Mangione question, I'll probably push it back. It probably won't be on tomorrow's morning report, which, by the way, got the mugs. But probably on Tuesday or Wednesday, once I've really had a time to answer this question, because it'll probably be like 5 words of the morning report, but I still want to make sure I have the right answer. So, but we will be talking more about this over the next few days. So thanks a lot, everybody, and have a wonderful evening, and I'll see you all in the morning, bright and early. All right, bye, everybody.